Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Asiedu Entry. Today we are looking at law of contract. Specifically, we are treating the kinds of mistake, and today we are looking at mutual mistake. It wouldn't take much of your time as we've already dealt with the introductory aspect of what mistake is, understanding that mistake is one of the foremost vitiating factors that vitiate a valid contract. Don't forget that a valid contract has these elements: an offer, acceptance, intention to create legal relation, capacity to contract, and there should be a consideration. We've learned also about privity to contract, terms of contract, and today we are looking at vitiating factors. I've actually treated the introductory aspect of it, and we are looking at mutual mistake. When we say mutual mistake, clearly in any contract, the offeror makes an offer to the offeree. So let me represent the offeror as party A and the offeree as party B. So when A makes a promise to B, that promise is specific. It is speaking about something which is so definite and does not give any room for intendment. So ordinarily, B must accept or say otherwise to the said offer. Now, when we say mutual mistake, here, let's say A is making an offer to B for a PK, a chewing gum PK, but on to the contrary, B is also thinking of the fact that, oh, A is offering to sell Tom Tom to me rather than a PK. So A thinks I am making an offer for PK, and B is rather saying that I think it is Tom Tom. So here there is a mutual mistake. Mutual mistake in the essence that both parties are mistaken on what they are contracting on. Both parties are mistaken on what they are contracting on. Maybe in the normal ABX examples we've been doing, A is contracting with B, and A is making an offer of X to B. B, the offeree at the receiving end, is thinking that A is rather offering Y to him instead of X A intends to send to. So clearly, if you remember and recall what we treated in our nature and essence of making a valid contract, in fact, we stated that there should be that freedom to contract, and the offer, when we were treating offer, we mentioned that the offer must be definite, specific, and final. So if it is definite and specific to mean X, and B is thinking it is Y, then clearly there is no meeting of minds. Their minds are not ad idem. Their minds are not ad idem, and as such, there can be no contract. You recall the cases of Scriven Bros versus Hindley and Company. You get to know that one was quoting per piece, the other is also quoting per pound. At that particular instance, there is no meeting of minds. You recall the case of Falk versus Williams. Falk versus Williams, where the other person was thinking that he's contracting from Fiji to Barcelona, and the other person is also thinking of from England to Sydney or so. And clearly there is no meeting of minds. So basically, when we talk of mutual mistake, what I want you to take home is that here, party A, the offeror, is contracting on a different or making an offer for, let's say, X, which is far different from what the offeree on the other hand, that is party B, is thinking of the offer maybe being Y and not X. So there is no meeting of minds. There is no meeting of minds, and as such, we say that both of them are making a mistake, and as such, the said mistake is mutual. It's mutual on both ends, so there can be no contract, and such a contract cannot be enforceable as both parties did not or were not actually in ad idem. Thank you very much for enjoying this session. This is the Law Lab. Today we've treated mutual mistake, and we have understood that such a mistake is not enforceable under law. And I would implore you to like, share, subscribe, tell a friend to tell another friend. Up next is unilateral mistake as to the contracting party. Thank you.